Hi, this is Michael Cohen. I'm a Dallas estate and elder law attorney. I'm welcome. I welcome my good friend and I'll call him co-host on this show or podcast, Don Crawford Jr., who we had a radio show together. He owned the radio station, sold it, but he's graciously continued to do podcast with me. He's joining me, thankfully, from his hotel room in Rochester, New York.
Go figure.
He
Mhm.
couldn't wait to see the Lilac Festival. I think that's
Yeah,
what it was. Either that, he wanted to see maybe go to Niagara Falls. I don't know.
yeah. I think it's the Apple Festival here. They're big on their
Oh,
apples.
oh,
So go figure.
well,
Lilacs, Texas, I think, and Apple is up here in New York, Western New
okay.
York.
Okay,
Yeah,
well, there you go, Johnny Appleseed, right here
that's
on our
right.
show.
Exactly.
Okay, so today's topic is going to be about how somebody on their deathbed gave a beneficiary designation that was not complete, which benefited his ex-wife as opposed to his wife.
That's right.
All right, so what happened here? I'll just say Gary and Kathleen, because those were really their first names.
Okay.
They were originally married for 25 years. They had two kids, but they got married, got divorced after 25 years in around 2015 or 16, 2016. They got divorced, and in 2016, rather, he got remarried to a woman whose name was Tiffany. But shortly after the marriage, they both got ill. He had stomach cancer, and she was very ill too. They both got hospitalized by the end of the year,
Yeah.
and so he had went to the hospital after, and then when he was discharged, he was Tiffany's sibling and family members helped take care of Gary for a short period of time. But they not very long afterwards, they said, this is kind of a pain. We're not even sure about he knows what's going on, but we're going to take him to the hospital because we want him off of our hands.
Right.
Well, the
And
very same day, the hospital said, well, he's not bad enough. So they called, instead of going back to Tiffany's sibling, sister to take care of him, a friend called, and the friend picked him up and brought him to his ex-wife's home to take care of him.
okay.
Well, the ex-wife did. He was a postal worker, and so as a postal worker, he could go with the federal program to get life insurance. So at the beginning of 2017, when he was at his ex-wife's home, after he was hospitalized that one day by his wife's family, he entered and got a life insurance policy. On that, it tells you you're supposed to fill out your form like any type of life insurance policy. You fill out the boxes and you fill out what's going on. So he named for two disinterested people, two witnesses, he signed that his ex-wife would be the beneficiary, not his wife. They sent it in. However, when they sent it in, they didn't check off all the boxes. So the life insurance company, through the federal government, declined the beneficiary designation. Well, they sent it back to her. And he said, okay, I'm too weak right now. Ex-wife, you fill in the boxes. Well, she filled in the boxes,
Yeah.
but it was sent the day after he died.
Oh boy.
So, so the insurance, the federal insurance company said, well, you didn't finish it outright, so it's going to, as a matter of law, it goes your closest relative, your spouse, as a matter of law.
Hmm.
Kathleen, the ex-spouse who was named the beneficiary, uh, she appealed and she went to court at the appellate level and said, um, "Hey, no, no, no." She sued, and well, actually, she didn't appeal. She sued and said, "Look, this was substantially complete. We had two witnesses." So the lower level, and then on appeal too, said, you know what? It was signed before two witnesses, and so it was substantially complete. So we're going to allow it. Well, the
Amazing.
the spouse, I mean, in the meantime, the spouse also died, and it was now up to her estate. And they said, well, he didn't know what he was signing.
Right.
He lacked the capacity, but they didn't give enough proof. 6 years later into the lawsuit, the court said, we've given you extension after extension, and it's hard for us to believe that, that you uh, haven't gone to us. They're saying, she said, oh, the ex-spouse didn't cooperate, wouldn't give us HIPAA, wouldn't give us the ability to have access to the medical records. She
Mm.
apparently had access to medical records, but she wasn't going to cooperate. They said, well, we've given you extension after extension.
Right.
It's been 6 years. We find it hard to believe that you couldn't go to court to ask us to intervene.
True.
So, because of that, you're out. So, ex-spouse was the beneficiary, as it turns out,
Amazing.
of the life insurance policy, even though it wasn't fully completed.
It's a bit rhetorical, but I wonder why she waited so long.
Well, I don't either. She got poor legal advice,
Right.
and part of it was probably delayed because she had to be named as the executor of the estate of her mom.
Right.
So it was the daughter became the executor of the estate. So I don't know how long it is to probate. This was I believe it was a Massachusetts case. And so I don't know how difficult it is to probate in Massachusetts. In some states, it's much more difficult than others. Sometimes here, it's usually fairly simple to probate if it's done properly. But a lot of times there's still, even if you had had a trust in this case, you would have to collect. So you may have had to probate anyway with a pour over
Right.
will. Well,
Right.
anyway, in some states it may be more difficult in Massachusetts than it is in Texas. I'm not licensed there, so I do not know.
Okay.
Um, but the bottom line is, and then she said, "Oh, I need more time. I'm asking this, I'm asking that," and she just didn't do it the right way. And the courts were saying, "We don't believe you anymore. We're giving you this extension, and now you're wanting more this hearing, more." And it's, enough's enough. So a lot of times judges decide based on the characters probably, and uh, in this case, they thought, well, I don't know, it was signed before two witnesses. I wonder, too, though. My question would be, they only brought up the issue of capacity, but usually when you have a contest, there are two main things that people contest as far as whether, like on a will. Capacity is one. The second is undue influence. He was at her home. He had some weakened mind, apparently. She helped sign the different things, but they didn't bring that up in the case. So
Wow.
I would think that counsel, I'm not a litigator, I'm a nerdy planner. But the thing that we usually do, a lot of times, like even when you sign a will and things like that, a lot of times you don't have the beneficiary in the same room because that could raise the question of undue influence.
Right.
Here, she was there. She even helped finish the form after the first attempt. He was obviously weakened. They felt like there was a need to have witnesses. So maybe that was in the form. But whatever the facts are, this is a case where the ex-spouse got the life insurance, not the existing spouse or
You know,
her.
I watch sometimes a show called Dateline, and this guy murders somebody and this kind of thing. And whether it's Corey Richins that we talked about last program or somebody else, they all think they're the smartest people in the room and they're going to outsmart the really smart guys, the police, the FBI, et cetera, et cetera. And then they forget about certain things and no one remembers everything and they get caught. Um, so don't do that. Don't play smarter than somebody else. Don't play attorney. Don't do any of that. Leave it up to Michael and let the attorneys decide if you have a case in or not. Well, mine's really easy, but it wasn't. This guy just missed a few boxes to check, and then all heck broke loose. And you shouldn't play attorney either. You should just leave it up to the experts and let them decide what is right and what is wrong regarding your case. And this is why you need to attend Michael's next workshop to make sure you get all your questions answered and then go to the vision meeting after, which I think most people do, to make sure yours is evaluated individually to ascertain exactly what circumstances you have and if they need attention. Michael?
Yeah, I mean, the workshop is free, no obligation. The vision meeting, which you're referring to, is for those and only for those who attend the free workshop,
Okay.
have the ability to have another hour meeting, not right after the workshop, it's
Right.
scheduled.
Right.
And we go over your individual circumstances. It's no obligation, it's free. And we just see whatever it is that's on your mind. I'm sure it's not going to often, we probably talk about beneficiary designations. That is something that we often talk about and probably always talk about at each one of these workshops, but we also talk about you never know what questions are about. The most
Right.
common things are on wills and trust and powers of attorney, but a lot of times it's on Medicaid, how do you
Right.
get eligibility for public benefits,
Good.
could be any number of things. Well, anyway, and you learn from others. It could be on taxes, could be on the one big beautiful bill. It could
Mhm.
be on any number of things. It could be, well, anyway, anything in connection with estate planning or probate. We usually ask people what they want to know, and
Right.
we answer those questions. There is a small presentation as well, just over the basics. So if you do want to attend that free workshop, which you would be entitled the free vision meeting that you referred to, Don, you would just sign up online at dallaselderlawyer.com, dallaselderlawyer.com, or sign up online, or call us rather at 214-720-0102.
Thank you, Michael.
Well, thank you, Don. I appreciate it, and we'll be talking to you real soon on the next podcast.